Okay, the next item on our agenda is what do judges look for in judging teams? Always a hot topic because, of course, everybody would like to get as good a score as they possibly can. That's part of the way mock trial is run. We have today with us Judge Stephen Crocker, who's from the U.S. District Court of the Western District. He's judged for mock trial for many years. I believe he typically has been not the performance judge, but the presiding judge, yes, because we typically ask our judges to do that. And for those of you who are new to mock trial, we actually have two types of judges. One is the presiding judge, whose primary function really is to run the trial that you've got, although they can become a tiebreaker. And then we also have with us attorney Michael Pollack, who's an attorney from Milwaukee. I almost said Mickey because I've known him forever. Our kids went to school together. But he's often been a performance judge both at the regional level and at state level for many, many years. The performance judge, and they'll talk about this a little bit, is the person, and there's usually two of them, who is looking specifically at the performance. Because what you'll find in scrimmages, and some of you have had the opportunity in scrimmages to be judges, is that in scrimmages sometimes you get asked to do both, and it is almost impossible to do both well at the same time.
All right, well, again, my name is Steve Crocker, and what I'd like to talk about for maybe 15 minutes or so is how to maximize your team's score during a competition. And this is from the perspective of a presiding judge. And just to reiterate a little bit, the presiding judge always enters a score, but it's never a numerical score. It's just a winner or a loser. And I'd say it's fairly common that you get split decisions. Those of you who may have done this before know that a 2-1 ballot is not uncommon. And as I'll talk about a little bit more in a moment, oftentimes the split in points is very small. So a point here, a point there can really make a difference. Now, having said that, of course, this is really an educational experience. It's not just about winning, and not all the teams are going to do well. And it's going to be up to you to keep your teams motivated and make sure they're having fun no matter what, okay? That's the key here. Are they engaged? Do they like it? Is this really encouraging them to think about either a law career or just a way to get engaged in the give and take of a dialogue as a lawyer might? But that's not what I'm here to talk about. So I'm going to focus a little bit more on what the judges look for. And so with that as the starting point, here's the caveats. Here are the grains of salt at the front end. There is no talismanic answer to this question. There is no one right answer. What works for one set of judges or a couple of judges on one panel is not going to work for other judges on other panels. And there's really no good way for you or your students to know that before the competition begins. And sometimes you don't even figure it out until you get the score sheets later. So you've got to learn not to dwell too much on the scores you actually get. And there's a couple of reasons why you may have experienced this or you will experience this as judges and with your teams. First of all, there are a lot of really good experienced judges who have done this a lot and they've got good context. But there are an equal number of relatively new or brand new judges, both at the performance and at the presiding level, who have not done this before. And they don't have context, and they don't really know the difference between an excellent score, a 9 or a 10, and maybe a middling score, 5 or 6. I once sat with a scoring judge who, notwithstanding the directions in the booklet that he would have read, said, I always started at a 5 and worked my way up or down from there. And so those students got a lot of 5s and 6s from this particular judge. Well, there's nothing you can do about that, and there's nothing your students can do about that. So you just have to expect that there will be some disappointments and some unexpected scores out there. So that's something you need to think about when encouraging your team to get ready, when encouraging between rounds as to how they think they may have done, and also at some later point perhaps talking to the parents and the friends of the team about, well, why did that happen? Why were the scores so bad? And the short answer is, well, you just can't always account for the scores you get. But having said that, let's talk about ways to maximize the score. And I suppose one way to look at it is a pyramid, kind of like Maslow's hierarchy of needs. You start with the basic stuff that everyone needs to do right, and then depending on how hard your kids want to try, how hard you want to push them, and how important winning is to you, you work your way up from there. Well, at the beginning, poise and demeanor is important for everybody. And you've heard some good advice about that from the coaches who spoke a moment ago. But from a judge's perspective, that's one of the keys. If you've got lawyers who are poised and confident in a courtroom, who walk around like they've been there before, who can take a hit from an adverse ruling or perhaps an unexpected answer from a witness and look like it didn't faze them and just carry on, that's going to carry over into a good score no matter what questions they ask or what answers they get, because that shows that they're acting like a lawyer is supposed to act. And something I want to emphasize is that it's not just poise in the courtroom during the competition, but it's at every moment after you enter the courthouse. We would all like to think that judges will compartmentalize. In fact, it's their job to compartmentalize to what they actually see in the courtroom, that's admissible evidence and so forth. But I don't think any of us would want to be in a situation where we were a coach and our team members were out in the hallway saying perhaps some mean things about another team or perhaps using inappropriate language, and it just so happens that one of the judges who either has or is about to judge them walks by when that happens. So again, starting with the very basics, from the minute you get on the bus or at least once you enter the courtroom or the courthouse, tell them that they're always on best behavior. You have to assume that somebody is watching and listening. And that would be true for real lawyers, too. You never know who the jurors are. You never know who the witnesses are. You don't know who the court staff are. So you have to act as if everything you say is going to be reported back to the judge at some point. Okay? Clothing matters. Now, of course, costuming is not allowed, and nobody would do that. But it's important for your lawyers to dress like lawyers. It doesn't seem like a hard thing to do, but you will occasionally have students show up in blue jeans and T-shirts. And maybe somebody lent them a sport coat that doesn't fit very well. And I'm not talking about like going out and buying a new Brooks Brothers suit. I mean, obviously we've got issues with people who maybe don't have suits and you don't want them to buy a suit for this. But if you're going to be a lawyer in a competition, you at least want to look the part because that's going to project well to the judges. And again, it's about trying to maximize scores. And if the judge is thinking of you or your student as a lawyer, and they look like a lawyer, and they walk and talk like a lawyer, that's much easier for the judge to treat them like a lawyer and give them the higher score that you think they deserve before they even actually ask those really insightful questions that you wanted the judge to hear. Now, I'm not here to tell you how to make that happen, but obviously, it takes a lot of practice to get kids comfortable walking and talking about a courtroom in front of strangers. We all have crutch words. We all have tics, both verbal and physical. We don't even know them until somebody points them out to us. For the brief time that I was a coach, which was very stressful to me, much more stressful than actually being a judge, we had de-ticking exercises. And at first the kids were just horrified that they were being called out by their peers on their crutch words or their physical tics. But it got them to the point where they were actually fluid and able to walk about and speak well without the wells, the ums, the ahs, the okays, the things that they don't even realize they're doing. And judges often don't even pick up on that consciously, but it's there, and the judges will probably notice it in some fashion. So once you've got sort of the backdrop, there are some fundamentals, just the basic plays that everybody has to know how to run. You have to know when to sit and when to stand. And the basic rule is if you're speaking, you're standing. And that's usually true, but they should know that. They should know that before they open their mouth, they're on their feet. If you are defending a witness and you are the person who has to object, you have to be sitting on the edge of your chair on the balls of your feet with your knees bent so that if you need to stand up and object, you are on your feet before you start objecting. Again, it's simple little things, but if they've never practiced it and they don't know it, they're not going to do it. It won't be automatic. But if they do it automatically, again, it projects well. It projects that they're good attorneys. Handling exhibits. Some judges are more punctilious about this than others, but there's no substitute for doing it exactly the right way. It's all in the book. There's really no reason not to practice that and have every lawyer who might handle an exhibit know the exact drill in the exact order. And it's not just enough to say, well, read this and then be ready to do it. You practice it, and you practice it until it's second nature. So that when they have to put that exhibit in, either the one they were planning on using or perhaps during cross-exam, the one that was in reserve, it's second nature to them. Again, it shows poise and fluidity in the courtroom that is going to project well in the scores. As part of that, you have to have disaster drills. The what-if scenario, the worst case. What if everything goes absolutely south on you? What if your witness melts down on the stand? What if somebody asks you questions that you have no idea were coming? Then what? Well, you can't think of everything, but I'm sure your students are pretty creative. They can think of a lot, and those are the kinds of things where you want your students, your team members, to be thinking about, no matter what happens, I can handle it. And that will reflect well. Maybe it'll never happen, but if it does happen, it will reflect well to the judges and to the score. Now, you've already heard some talk about how to present the case as a whole, and I can only concur in what the coaches told you in the previous presentation earlier this afternoon. Every case, either as the prosecution or as the plaintiff or as the defense, should have a beginning, a middle, and an end. I mean, it should be Aristotelian in its elegance. You've got to have a theme, and you have to have an ending. And in real life, as the lawyers among us know, you usually start with the closing. When I'm talking to the jury, or when I'm talking to the judge, or whoever the other decision maker is, whether it's the parole board or whomever, what are the points that I want to be able to make to them, and what evidence do I need to have in the record to be able to make that presentation? And once you know how you're going to end, you can work backwards from there, figure out what evidence needs to come in, figure out from which witnesses it's going to come in, and then have your students, either on direct or cross, make sure that they adduce that evidence in the appropriate way. And sort of the flip side of that coin is, if you don't need it in the closing, you probably don't want it coming out, or at least you don't need it coming out. Because don't forget, time is an issue. And you don't want to run into a time crunch. You don't want to have your closing argument down to 30 seconds before you hit a penalty. Because let's face it, that's going to be a pretty low-scoring final argument. The judges will be sympathetic, but the rules are what they are. So you want to marshal your time and shepherd it wisely during the competition. So there may be some really long affidavits. If any of you have worked with some of the more recent cases, we've had some really long expert depositions by scientists and medical doctors and psychiatrists. And what you end up with is students who have memorized the entire affidavit and can sort of regurgitate it. But a lot of it isn't really necessary, and it doesn't have to come in on direct because it really doesn't advance a point that's going to be made in closing. So again,